Welcome, and thank you for tuning in. You're listening to the Beyond 50 radio program. I'm Daniel Davis. On the program today, we're going to be talking about something that can sometimes be a foggy, sticky issue for most of us who don't really understand what it is, and that is the First Amendment. Most people, in fact, I believe surveyed would believe that when you go and you talk about what the First Amendment is, would certainly first of all say, well, isn't that about the freedom of speech? Well, sure, let's take a look at what that freedom is, how it came about, and what it actually means when it comes to American democracy. On the program today, we're going to be joined by First Amendment attorney Floyd Abrams. He's going to be talking with us about the constitutional dangers threatening freedom of speech coming from the left as well as the right. We'll also learn about repeated conflicts between claims of free speech and those of national security, such as we see in the case of WikiLeaks and also the case of Edward Snowden. We'll also be talking about what could happen if we start loosening the libel laws that are really meant for America. I'd like to welcome to the Beyond 50 radio program today someone who has extensive experience when it comes to this, someone who has litigated First Amendment cases ranging from the Pentagon Papers as well as Citizens United. He's also taught at the visiting lecturer at the Yale and Columbia Law Schools and is author of Friend of the Court on the Front Lines with the First Amendment. I'd like to welcome to the Beyond 50 radio program today our guest and author of The Soul of the First Amendment, Floyd Abrams. Floyd, thank you for joining us here on the program today.
Oh, it's good to be here.
You know,
Thanks for asking.
I was really surprised by this book just right off the bat that it was such a quick read.
Well,
but
I tried.
compelling for the most part. No, usually you would think something like this would go extensively and tear apart, you know, going back to history and this and that, but you actually jump right in with what it is. But first, what I'd like you to do for our listeners, let's give clarity about what exactly the First Amendment is.
Well, it is a provision of law which limits the power of the government. It limits the power of the government with respect to speech and press and religion and assembly, and it basically says that these are not areas into which the government may rule, make determinations, carry the day, etc. Now, obviously, there are a number of situations in which one has to make a decision as to just how far that means or just what speech means. I mean, the language of the First Amendment talks about Congress. Congress shall make no law abridging the freedom of speech or of the press is one element of the First Amendment. Congress has been expanded through the years to mean not just Congress, but the president, not just the federal government, but the states, and not just the presidential level, but officials of all sorts around the country. But taken as a whole, what it means is that in these very sensitive areas, that the government may not make the ultimate determination of who can say what and ultimately who can think what.
Now, let's take a look. I was really kind of surprised, I suppose, when it came to, you know, first you've initiated the First Amendment, but you said that it was really almost non-existent until the early part of the 1900s. What was going on with that?
Well, for one thing, there were no cases. Maybe there weren't enough lawyers, or maybe we have too many now. But there really weren't a lot of cases in the courts involving the First Amendment, or indeed involving much in the way of the Constitution. I mean, there were some very famous ones, but not ones about free speech or free press or freedom of religion or the like. And it really wasn't till the earlier part of the 20th century with World War I and issues arising as to, what sort of speeches people could give who were against the war, where the government position was if you give that sort of speech, people won't enlist, people won't fight the war. And the other side was, well, if we're against the war, we ought to be able to speak against it. Well, in cases like that, really for the first time, and I'm talking, the 1920-ish or thereabouts, the court had to really face up to these really tough issues and start dealing with them, and that's where it all really began.
Now, it's also funny, too, when you think about those times, how limited we were in mediums compared to today.
Yes.
I mean,
Absolutely.
goodness gracious. I mean, here's one funny fact I remember someone stating, and I've actually used this when you go to the YouTube threads when people make comments about anything that we post up there for our program, and he says, you've got to consider when you go to the internet, for instance, that it's basically the bathroom wall of the world. But when you look back on these times, like you're talking about during the times of World War I and even before then, there were limited mediums that were feeding information that actually could have what you would consider to be quite a bit of control over public opinion or public ideals. And so you wonder, okay, now that you started, as you're saying, seeing cases kind of come to light which should afford that protection that the First Amendment supposedly guarantees us, that you kind of wonder, how much was public opinion swayed or directed as a result now that we hear about, Donald Trump always touting about misinformation and, and bad news and so forth. And you got to take a look at this and say, where do we stand with all this, now that we have such access to so much?
Yeah. Well, really two thoughts. One, the people who generally tend to need the First Amendment are people who don't have power. The people who own newspapers can have their say, but the people out of power. And so these first cases tended to be socialists, anarchists, and the like, who never won an election, but were out there speaking against World War I in one way or the other, or against the structure of American society as it then existed. And those were the first sort of cases that came up. Now we've come so far in the last century, say, since those cases began. We went into World War I 100 years ago this year, and since then, I don't have to say how much changes there have been in the way of who can speak and how, given the internet. It has been an astonishing change in terms of the availability of a platform in which one could have one say, in which one didn't need a lot of money to do so, in which you didn't need to get permission of anybody to do so. You didn't need a license. And all those things are major changes in the way that public opinion is formed, and to which the availability to the public as a whole of the chance to speak out.
So let's go ahead and give people perspective about this First Amendment. Now, this is the idea that, the government can make no law that steps in and tells you what you can and cannot say, in respect to the fact that should they do this, that you can actually be punished by law as a result. So you start off in your book and you talk about, for instance, the statute that involved Colorado back in 2000, and this is in regards to abortion and abortion clinics. Let's talk about this, for instance, because sometimes, as you well know and as we have heard, situations about opinion and about what people think and feel about pro-life, pro-choice, things like that. This is one of those. In fact, I remember an episode of Seinfeld where I think it was Elaine was talking about how open-minded her new boyfriend was, and Jerry snarks and he says, "Oh, really? So what do you think he feels about abortion?" But let's take a look at that, because sometimes this gets pretty ugly when it comes to opinion and freedom of speech.
Absolutely. So here's a case, that Colorado case, which arose when Colorado passed a law which was designed to clear the way for women who wanted abortions to go into an abortion clinic free of contrary pressure or the like. So they passed a law which basically says that unless the woman asks to speak to someone, that a person within 8 feet, I think it was, of her can't address her. That if the woman doesn't encourage or ask for commentary. So someone as close as 8 feet or less than that, as she walked towards the clinic, couldn't address her, and the argument was, and what a majority of the court held was, she had a right of privacy, a right to be left alone and not to be pressured. And the argument on the other side was, look, these are public streets, these are public areas, people have views, and they're entitled to voice the views, and they're entitled to try to persuade the women, as long as they don't get in her way, as long as they don't prevent her somehow from entering, but they have a right to have their say and to try to persuade them not to have an abortion. Well, the Supreme Court in 2000 affirmed the constitutionality of the Colorado statute, said that it was constitutional, and not till 17 years later, or 14 years later, did the court have another case in which they went the other way, in which the law now has come to be that, look, if you're not interfering with someone's passage, you're not allowed to block a woman from going into there, and you're not allowed to threaten her, but can you try to persuade her? Can you talk to her, even if she'd rather not? The court said, yeah, that's how could that not be protected by the First Amendment? So it's a good example of a topic on which, first of all, people disagree enormously. I mean, on both sides of the aisle, and in which the issue of, well, what can you say and where do you have to be? And at what point does saying something become coercion? That's what makes the case, and both of these cases, ones in which you really need a court to make a decision on which side of the line it falls. And the more current law, the rather recently established law, is that it's one thing to protect a woman from overt coercion, threats, blocking her, but it's quite something else to prevent a speaker from trying to urge the woman not to go ahead. And it's the second view, which is the more First Amendment sympathetic view, which has carried the day. But it did not in that 2000 case, which is now, I would say, no longer a good law.
Yeah, and I found that striking because as I broadcast out of Portland, Oregon, certainly this can be considered a very liberal state in its views, and there are a couple of things we can cover later on. But the one that I'd like to talk about real briefly that had actually occurred here, and this was probably about 8 years ago, is there was a man who was driving around a truck with a trailer that was custom painted. And this was someone who was definitely anti-abortion because on the side of this trailer of this semi-truck, what was custom painted or shown were actually ripped apart fetuses as a result of abortions.
Yeah.
And he was freely driving this around through downtown Portland on both the west side, the east side, you name it, and generally during times of high traffic, during business hours, so forth, and sometimes he would park it in areas where there was a lot of high-volume traffic, and he got a lot of ire for that. And you think, boy, this could really turn into not only a potentially explosive situation, but a very violent one as well. And so when I was looking at this, I thought to myself, I was kind of reflecting back to a time when broadcaster, producer Tavis Smiley with the Public Broadcasting Network did a series regarding the First Amendment, freedom of speech and expression, in which he was doing panel discussions with people that seemed to be, from more or less to me, more from different areas of entertainment. Like one night they would have, for instance, Roseanne Barr, rapper LL Cool J, and then Larry Flint of Hustler magazine. And the one thing that he really pointed out that I thought was curious but a really good question was, okay, I see what you're talking about here, but where do we draw the line on what this First Amendment really means and the responsibility that goes behind it?
Yes, yes. And that is the question which comes up so often in these cases. Look, we even have disagreement, significant disagreement, as to what we mean by speech. Someone burns an American flag. Is that protected by the First Amendment? Well, the Supreme Court has said it is, that's a form of communication. It's a protest against whatever the people that did it are offended by. That was, when it came out, a very controversial opinion of the Supreme Court, and it was not the same side of the line that the court probably would have come out with 30 years earlier. Times changed, the composition of the court changes, and people take sort of new looks at, what do we mean by the First Amendment? What does it mean to say no law abridging the freedom of speech or of the press? And in that case, the court got to the position and said, look, this is only a protest. That's the only reason they're doing it. That's all it conveys is a protest. How can that not be protected by the First Amendment? That is the law today. But I wouldn't minimize the difficulty of sometimes deciding how to draw a line. It's just that one of the things that my book argues is that we draw the line in a way which is more protective of speech and press and the like than any place else in the world, and probably any time in the history of the world, in terms of the sort of communication that we protect and the degree to which we protect it.
Now that you've brought up how different this is from the way the rest of the world in many ways, and we even can talk about, let's say, our sister country, which would be the United Kingdom, if you will. And you talk about the relevant differences there, and, as you begin to let people see this through the reading of your book, The Soul of the First Amendment, they realize, in a way, just, I guess, how blessed we are and how it seems slowly but surely this particular unusual, if you will, document has begun to seep into other cultures around the world. For instance, if you take a look at the liberation of Egypt, for instance,
yes,
and the idea of democracy, it seems that this so-called American experiment, which I like to refer to it as, we've actually had this kind of discussion on the program from constitutional professors, for instance, and it's really astonishing that here in America, how we know we have a Constitution and a Bill of Rights. We know we have this thing known as the First Amendment, the Second Amendment, and so forth. But what's fascinating to these people, such as perhaps even yourself, is how little Americans understand what this is. What these rights are. I
couldn't agree more. No, I couldn't agree more. It is astonishing. And it requires more education.
A lot of due diligence, too.
Yeah, well, sure. One of the things I think it requires is trying to teach kids at an earlier age something about our Constitution, something about the level of our freedoms. The easy example is, at least in most places in the country now, we don't have civics courses. I had one in junior high school,
right?
They're just not around the way they were. But whether it's those courses or something else, it seems to me really important that we teach our children, and we can do it with a great deal of pride. That just the degree to which our country does protect dissident views, unpopular views. The speech, one Supreme Court justice said, the speech that we hate. We're really unusual in doing that.
Now, let's talk about how different, for instance, it is in other countries. And again, I brought up the United Kingdom because eventually what I'd like to talk about is libel laws, and I know I got myself in a snag with that, where I didn't even understand what libel was, but all of a sudden there I was kind of, it was actually in a journalism class where I wrote something and I go, oh, I could see how that would have an impact. But before we get to that, let's talk about just how different it is, what that means, because we're talking about a First Amendment here in the United States where it's the freedom of speech, expression, assembly, that we're allowed to do these without government overreach to decide whether or not those things are punishable, okay? Mm-hmm. And it's a much different thing when you're, let's say, in the United Kingdom, for instance, or even Korea. So let's give our listeners an idea of just how different that is and how, I guess, in a way we might say, blessed we are to have something like this in place.
Yeah, well, it comes up in a variety of areas. In England, you mentioned libel law, for example. England has been a great place for people who bring libel suits.
As you talk about, yeah.
Yeah, Hollywood
Liberace,
personnel.
for instance, yeah.
Well, Liberace brought a lawsuit against a paper that had suggested, and only suggested, that he was gay. And he got a big jury verdict in his favor, even though it turned out that he was. In England, it's when you get sued for libel and you defend on grounds of truth and you lose, you wind up paying much more in the way of damages because you even tried to defend on grounds of truth. One of the ways our law differs from that in England sounds technical, but it really isn't. It's sort of who's got to prove what. In England, if someone says something critical of someone else, he's got to prove it was true. The speaker has got to prove that what he said was so. In America, the general rule is that the person suing has to show that what was said wasn't true. And that's a big difference because the truth is it's hard to prove it very often. It's very often hard to prove it either way. So it matters a lot who has what the English call the onus and what we call the burden of proving the speech was correct or not, truthful or not truthful in one way or the other. Under English law, if you say something that is defamatory, it's really sort of bad, critical about someone else, the law assumes that charge was untrue, and you've got to undo that. You've got to prove it is true. And under our law, it's quite the opposite. We assume not the truth of it, but we assume that the person's allowed to say it. And then we go on from there. So the legal systems are very different, indeed so different, that just a few years ago, Congress passed a law adopted unanimously in the Senate and signed into law by President Obama, which said that, in effect, we're not going to enforce libel judgments issued in countries that don't give First Amendment-like protection, which really means we're not going to enforce a libel judgment entered in England. So there's a full trial in England. But the decisive legal proposition is that it might well have come out differently if it had been heard here under our more protective, more speech-friendly law. We won't enforce it. So you may have a judgment in England, but it is unenforceable. No American court is allowed to enforce it in any state, let alone the federal government. And that's true not just about England. It's about any country in the world. because we're the country that affords the most protection in this area. So to this degree, we sort of walled ourselves off legally by saying, we care so much about protecting free expression that we simply will not allow, will not give credit to. We won't enforce foreign libel laws, even if there's been a full trial in that foreign country, and even if it's a country which is basically liberty-loving country like England or like Canada, say, it's another example of just how different we are and how much more we protect free speech and free expression.
So I became curious because you think about freedom of speech, and you didn't talk a whole lot about this in your book, but I think of the world of entertainment, specifically Hollywood in the early years, and the idea of censorship and, of course, the Hollywood blacklist. And there didn't seem to be a whole lot of talk about that, but it seems to be something that's a lot different today than it was then about what we're allowed to put on the film, what we're allowed to see and experience on TV. And I started remembering, for instance, George Carlin and the 7 words you can never say on television. Mm-hmm. So what has happened there that so much has changed? Because to me it seemed that the First Amendment wasn't in play too much, and there was a lot of that going on that almost seemed to be government overreach in those arenas because, like in the case of the United Kingdom, you would see commercials, for instance, that were more risque and programming that was more sexual in content, way more than here in America, but how that seemed to be impeded here, especially in relation to this First Amendment and freedom of speech and expression.
Yeah, and the reason for that is that we have, to a considerable degree, treated radio and television differently and not provided as much First Amendment protection for them as has been the case with respect to, say, a newspaper. The theory being, at least, as the courts and as the Congress expressed it, that you need a license. The more people want a license than can have it, because there are just more that want it, and therefore that the government has a role to play in making decisions about who gets it and who keeps it. And so we used to have a law called the Fairness Doctrine, which basically said if on radio or television, you take a position on a public issue of significance as to which people disagree, that you have to put the other side on. Not the same program necessarily, not the same amount of time, but you have to put the other side on. Now, on one level, that may sound perfectly reasonable, and of course most broadcasters do that anyway. But it did empower the government to make a series of content decisions about what could be on and what not, and what is in the public interest and what not. That law fell under President Reagan, and it was abandoned. It was a rule of the FCC, which was dropped. But we were treating the broadcast industry, and to some extent we still do, as less free than newspapers, pamphlets, books, movies, other sorts of entities. And so in part, because of the degree to which people couldn't get away from it, the pervasiveness, the court said, of radio and television, as if you couldn't turn it off. but that's where they were then. That is no longer the law now. But the law is, it's not always so clear. We still have an FCC. It still passes judgment about whether certain matters are contrary to public interest. It is much more First Amendment oriented than was the case We just saw an example of this recently with some very, very harsh criticism of President Trump, as to which the FCC basically said, look, we're not going to get involved with that. No, I think that's the right decision. But I can tell you it wouldn't have been the decision 20 years ago. And I think it's a good sign that we're continuing to move in a direction of more protection for speech, including speech in the broadcast media.
Now, you were involved with Citizens United, and certainly there was a lot of talk, especially in the mainstream papers such as the New York Times and the like.
Yes.
It was talking about the concern of corporate spending for candidates, so to speak, and that this seemed to be a way of, and this is just my words, lightened in a way of influencing the political process. But you outlined that really wasn't so much the case. Let's lend some clarity about what that is so people have a better understanding of what was going on there.
The Citizens United case arose when a conservative group, partially funded, but not much actually, but partially funded by corporate money, prepared a 1-hour documentary in 2008 at a time when it appeared that then Senator Hillary Clinton would be the Democratic nominee for president. As we know, Senator Obama was nominated and elected. But this was a very tough, very anti-Hillary Clinton documentary, which, as the Supreme Court later said, was basically one which said one thing for an hour, which is she shouldn't be president. And the question in the case was, well, is a law which then existed, which basically said that you couldn't put such a program on television or cable or satellite within 60 days of an election or 30 days of a primary if it was at all funded by corporation. Was that consistent with the First Amendment? And my view was that it wasn't, that particularly political speech, whether one agrees with it or not, of course, but particularly speech about who ought to be president ought to be given the most protection and not ruled off limits to First Amendment protection because money spent in putting this together came from a corporation, and that is what the Supreme Court ruled. It's a very generally a not popular opinion. The polling data indicates about 80% of Democrats and Republicans oppose the ruling of the court. I think the ruling was correct. I was involved in that case, representing Senator McConnell, whose political views I tend not to share, but whose First Amendment views on this I do share, and that's the way the court came out. And one thing that had been predicted, which was that there'd be a flood of corporate money in our political campaigns, which would overwhelm everything else, has just turned out to be not true. I mean, the big money in political campaigns is from individuals, wealthy individuals, who have put in lots and lots of money, but not at all from our largest corporations, and in general, not much from our corporations as compared to individuals.
Yeah, it's such a fascinating conversation because you see what seems to be, as maybe our founding fathers maybe unintentionally intended. I don't know if there's such a possibility.
I think that's a really fair point. I mean, we really can't attribute to the founding
because
fathers.
The whole idea was they didn't want something that was set in stone, I believe. And again, I've had a lot of good conversations, and we're not certainly a political talk show by any means, but one that's kind of well-rounded beyond 50. By this time, people are really wanting to know what is the real history, from being a child, going to grade school, junior high, and high school, and being told this is the way history was, and then all of a sudden you start hearing a different story and going, wait a minute, I thought Christopher Columbus was this good guy that discovered the world was round, and you realize, no, he was actually a genocidal maniac. And you go, okay, so what else aren't we being told here? And there was one that really came to mind because, certainly this day and age, I'm sure this generation, perhaps the generation just before that, they look at Edward Snowden in a way as what could be considered a liberator because of what he had leaked out to the media to be published, especially in WikiLeaks. But I actually want to kind of go back in time because I can see the contrast and similarity between, for instance, him and Daniel Ellsberg. Now, this was something I came across actually about 8 years ago, and I'm like, who's Daniel Ellsberg? Well, it was because of a documentary that actually had more to do with, the name eludes me now, but he was the bigwig back during the Nixon administration. The glasses, who am I thinking of now?
John Mitchell? Or
No. He was, anyway, it'll come to mind. But anyway, he considered Daniel Ellsberg to be the most dangerous man in America.
Oh.
And it's because here was a guy that was actually in favor of what we were doing in Vietnam until he began slowly seeing the truth. And then he started saying, wait a minute, what we're doing over here is nonsense, and started speaking out deliberately about it. And the next thing you know, he was kind of in this conundrum about, is this the right thing to be doing? Of course, he felt that it was, but the government wasn't so sure about that. And here we've got Edward Snowden under the same situation here. And so taking a look at these things here, how do you consider these things to be as far as the First Amendment is concerned?
First, I'd say that we ought to bear in mind that what Daniel Ellsberg made public, the so-called Pentagon Papers during the war in Vietnam, was basically a history of how we got into the war. It was not. It did not reveal military secrets or highly classified information, even though they were all labeled as top secret, but not highly classified weapons related or anything like that, or secrets of state that no one had ever heard of. What Edward Snowden did was really, I divide into two parts. One, his revelations about domestic surveillance, how much the U.S. government was empowered to keep track of in terms of telephonic or other communications. And I've always given him a lot of credit for revealing that. He's also revealed a good deal of information about American intelligence gathering abroad, as to which I have very serious qualms, and my own political social views are that someone with authorized access to secrets like that shouldn't be revealing them. The important thing, though, is not what I think about whether Snowden served us well as a citizen, but your question. What's the law, or what would happen? We live under an Espionage Act adopted literally 100 years ago in 1917. It's phrased very broadly, and we haven't had a lot of cases under it, and we haven't had any against a journalist or somebody that claims to be a journalist, which is what Julian Assange at WikiLeaks claims. We have had cases brought against people who leaked information, people who had access to them, and as Mr. Snowden did. I would hope that the government would lay off, that they would not prosecute, that they would exercise a level of self-restraint. And I have that not only because one can argue about the social benefit of the leaking involved here, but really more important because if you read the Espionage Act too broadly, you really imperil a great deal of really important reporting to the public and commentary to the public about what our government does. And I think it's very important for the First Amendment to be read broadly enough to protect that sort of revelation to the public of information. And that is what both WikiLeaks and Edward Snowden have done. So it is a concern that I have as we read, about the government seriously thinking of prosecuting WikiLeaks, and my book is very critical of WikiLeaks, but I would very much hope that the government would not go down that path, which could really put at risk American journalists who are basically doing their job of trying to find out what's going on within the government.
So the name I was trying to think of, and I kept getting everybody else mixed in, including Richard Nixon, was Henry Kissinger.
Oh, yeah. I remember him.
I'm sure you do. But here was somebody that, in a way, when you got to know what he was doing, you realize, well, wait a minute, he's kind of doing what we're saying the government should do in many ways. He's trying to, but in a way, he's also practicing the First Amendment with his views and so forth. That, it becomes more intriguing when recently with the recent elections, that Donald Trump, for instance, is so outspoken about, the fake news and the fake media and how we need to shut all this down. And he becomes one of those kind of guys that although he, before, as he's building his career in real estate, decides he's going to move into the media, they're his best friends when he's making a bunch of money, and they're his worst enemies when he's running for president. And he gives the impression that he's going to shut all this down or do something about it. And you kind of talk about, ways that he could possibly go on about doing that by, using the Internal Revenue Service and the tools that could be at the government disposal to kind of roll us back to censorship again.
Yeah. Well, that's the risk. I mean, he has certainly talked more threateningly about limiting journalistic freedom, certainly, than any president in our lifetime. We'll just have to wait and see if he takes any steps in that direction. I mean, he has said, for example, that he wants to loosen, was the word he used, the libel laws. Now, that's one comment that doesn't worry me because there is no federal libel law anyway. I mean, our libel laws are state laws, so there's really no role for the U.S. government to even play on that. But I think what he really means is that he thinks that the courts, in the ruling that the First Amendment has to be taken account of in libel litigation, which is what the U.S. Supreme Court has said and is the regime under which we live, that he disagrees with that and might try to persuade the court to change its mind or appoint people to the court who would want the court to change its mind about that. I don't think that's a real big-time risk, but I am concerned. We've been talking about the Espionage Act. I'm really concerned about the use or misuse of the Espionage Act as a way to prevent or punish certain types of criticism of conduct of people in power.
Well, first of all, what I want to do is I want to thank you for taking the time to be on our program today. Again, we like bringing this up mainly to let people know you may have an idea what the Constitution and the Bill of Rights is, but it's better that you know for certain what it's about, because then you become more empowered about, first of all, just how fortunate it is to be born in a country like this, to have those kind of things in our corner. But if you don't know what they are, which apparently there were 800 undergraduate students that were sponsored by the William F. Buckley program at Yale, found that 51% of their students, they favored speech codes and trigger warnings, but that 35%, or somewhere right around there, really didn't understand or, what the First Amendment really was. And you talk about how it's important that we start educating these people at very young ages and not until, they get in college or get in trouble. What would you suggest to our listeners out there who want to find out more about this? Is there a website they can visit? Obviously, the Soul of the First Amendment is a good start for a lot of people who really want more clarity about what this is all about. What would you suggest?
Well, after they finish reading my book.
There you go.
It's hard to go to, really like a single place to go.
Get a copy of the Constitution, I would think.
Well, get a copy of the Constitution. I mean, the First Amendment's only 45 words. It's really short. I mean, if we've had some great legal opinions, which people can read. I mean, real people, non-lawyers, can read and understand. But like the one I mentioned about burning the flag. I mean, that's not an easy decision for the Supreme Court to issue. These were statutes, a state statute in Texas, a federal statute passed by Congress, which made it a crime to burn an American flag. And it offends all of us, or just about all of us, when somebody does that. So it's sort of counterintuitive to say, well, we really ought to protect that. But it's important that we protect that, and that we protect freedom of speech and freedom of expression more generally. And I think. I mean, look, in Portland, we have a situation now where there's a issue about whether a permit ought to be granted to these sort of alt-right groups after the terrible incident of just a few days ago when people died because some guy, the story, killed them. I mean, that's a First Amendment case. That's a First Amendment issue. And notwithstanding that, we're still trying to get our minds clear after this terrible, murderous attack by this individual, that on issues like that, the First Amendment's really clear, that we just can't keep people from talking, from holding a rally, from giving speeches, unless what they do is so off base that it really amounts to an incitement to commit criminal conduct.
Yeah, there it is, because it was the same way we were going from nationally publicized, obviously, after the elections with the protests we were having about, Donald Trump being president. Okay, well, that's fine and good, but when day 2 and day 3 started rolling around and businesses were getting their windows caved in and traffic was being literally stopped from people trying to get to work or go home, it's time to say, look, guys, this protest, it's fine, it's good, but now you're really starting to reach in and break laws. You're impeding, things. And it's almost, in a way, like going to the drug laws, whether it's marijuana, whatever the case is. Look, if you're going to go ahead and use it, okay, we shouldn't really stop you from doing that. But if you do things that break the law, for instance, harming other people or drinking and driving, for instance, that's a danger, then there's something different here.
Absolutely.
And that's exactly
Absolutely.
what
and
you're
and
talking
that's
about
the exactly, and that's the sort of core distinction that we make. Of course, you're not allowed to break windows, and you ought to go to jail. You ought to be punished if you do things like that. But at the same time, we have to keep the lines of communication open and the right to dissent protected. And sometimes it's hard to do that when the people exercising their First Amendment rights are sometimes loathsome in their behavior beyond their speech.
Agreed. The book is The Soul of the First Amendment. Our guest joining us here on the program, Floyd Abrams. Floyd, thank you so much for being on the program.
Thanks. It's been a pleasure to talk to you.
Yeah, and is there a website people can go to?
No.
Okay.
No.
Well, we'll
got to buy the book.
Okay. Floyd, thank you again for joining us on the program
bye-bye.
today. I want to thank you, the listeners out there, for joining us. You can discover more. Visit us at beyond50radio.com. That is the number 50. We encourage you to sign up for our weekly e-newsletter. Stay up to date on what's going on in the world of Beyond 50, as well as our upcoming programs. I'm Daniel Davis. Thank you for joining us. This is the Beyond 50 radio program. And remember, live your day past halfway.